This meeting is being recorded.
Hello, good afternoon, and welcome everyone. Thank you very much for joining this session today. This is actually fourth webinar from our series of quarterly webinars that we are holding in Malta. I'm very much looking forward for today's session, and we have an excellent panel available to share their expert opinions on the very hot topic around ultimate beneficial ownership, the key regulatory guidance, industry challenges, and best practices. So this is going to be a very interactive, very engaging session today. So myself, very much looking forward to take part, and all of my panel members are here to help as well. So very brief introduction about the panel members today. So we have Becca from International Compliance Association. We have Geraldine from Malta Business Registry, MBR, Petra from MFSA, Carmela from FIAU, and we do have Stefan from Malta Association of Compliance Officers. So myself, most of you would have known me. Those who don't know me, I will briefly give a little bit background about myself as well. My name is Amar Ahmed. I'm the managing director and founder of Sigma Risk. So we are a financial crime and compliance focused consulting firm based in UK. But we do work with our clients, and there are several regulators and law enforcement all over the world. A little bit about myself, my background. I'm a subject matter expert in financial crime and compliance. I've had years of experience in identifying and assessing financial crime related risks, working with a number of institutions, largely financial institutions. Currently, my professional affiliation is with multiple institutions, including I'm a fellow member of International Compliance Association, ICA. I'm a faculty member of ICA as well, and I'm a faculty member of University of Aberdeen in the UK. Last but not least, I'm also a faculty member for International Chamber of Commerce Academy. So a little bit background about myself. Now, what I will do, I will request my fellow panel members to kindly introduce yourself, who you are, a little bit about your professional background and your current institution. What do they do? So I'll start with Becca. Becca, over to you. Thank you.
Thanks, Amar, and thanks everyone for joining us today. So, yeah, I'm Becca Dare. I'm the Vice President of the International Compliance Association. Many years in industry, as originally a lawyer looking at organised crime, but then also as MLRO for AXA, which many of you will know. Of course, AXA, a huge corporate, and then latterly a head of financial crime role in Lloyds Bank in the UK. But I've been with the ICA for about 15 years now. My role now is to lead on sharing good practice around the world with compliance professionals, and I represent the ICA at events all around the world. We do training with pretty much all the large institutions. Have done a lot in Malta over the years. Yeah, and just I'm in a really lucky position, a bit like Amar, in that I see what's going on in the space with lots of different organisations and regulators and different industries all around the world, and this topic today is a really important one. So happy to be with you, and hopefully can share some good insights as well. Thank you.
Thank you, Becca. Geraldine, over to you, please.
Thank you, Amar, and good afternoon, everyone. So I'm Geraldine Spitzer-Lucas, a lawyer by profession. I've started my career in the private sector, and then some 8 years ago I moved to, at that time was the Registry of Companies that was housed at the MFSA, and then later on we had a rebranding, etc., and we became a standalone agency known as the Malta Business Registry. Currently, I hold the position of Registrar of Companies and Other Legal Persons, and also CEO of the Malta Business Registry. The MBR is in charge of providing information, basic and beneficial ownership information on all commercial partnerships, including companies, and also other organizations, and also in charge of the register of beneficial owners of commercial entities and all types of legal entities. We have been granted last year a supervisory role, and therefore we had to move from a passive role, which was used as a registry we were seen that we just have documents and we proceed to registering them. By being granted the role of a supervisory authority, we are obliged to ensure that all the information provided to us is accurate and up to date, and we are doing our utmost in that regard as well.
Thank you, Geraldine. Carmela, over to you, please.
Thank you, Omar. Good afternoon, everyone, and thank you, Sigma Risk, for inviting FIAU to this panel discussion today. So my name is Carmela Loredana Umbro. I am a lawyer and I work for the FIAU. The FIAU is the Financial Intelligence Analysis Unit and is the national central agency responsible to combat money laundering and funding of terrorism. So this important mission is carried out through different sections in the FIAU. We have the analysis section that basically receive information, process, and then disseminate this information where requested to other FIAUs, the police, always information obviously related to money laundering and funding of terrorism. Moreover, the FIAU is the national supervisor of AML and CFT. This means that we carry out examination on AML and safety subject persons on-site and off-site examination to make sure that actually subject persons are fulfilling their obligation in terms of AML and CFT. So coming back to myself, as I said, I am a lawyer and I work within the legal affairs section of the FIAU. My team is the guidance and outreach team, so we take care of assisting subject persons in their understanding of their AML and CFT obligations, and through, for example, drafting implementing procedures. We have implementing procedures part 1 for all subject persons and sectorial implementing procedures, then interpretative notes and guidance notes in general. Moreover, we also assist the subject person replying to queries, for example, and in general providing training, internal training to the FIAU and external training, like we take part so for subject person, and we take part in general to other outreach initiatives, such the initiative of today.
Thank you. Thank you, Carmela. Thank you very much. May I request Petra, over to you, please.
Hi, good afternoon, everybody. Thank you, Sigma Risk, for inviting MFSA to this webinar. I am Petra Camilleri. I am also a lawyer by profession, and I started off my career with a small stint also in a private law firm in Malta. And I joined the MFSA in 2012. I actually, in fact, joined the trustees and CSPs supervision team within the MFSA. And I'm today the deputy head, in fact, of this section within the MFSA. As part of my role, I oversee, in fact, the team responsible for supervision of trustees and company service providers in Malta, which is, in fact, a sector which falls within the remit of the MFSA. Because although the MFSA as the financial services regulator is generally perhaps associated more with the traditional financial services, such as the banking, investments, and insurance. However, it is also the supervisor of trustees and CSPs in Malta. And I oversee the team responsible for supervision in this area. And we do, in fact, on-site and off-site supervision with respect to our licensed entities in these sectors. My specific contribution, perhaps, to this discussion today is that the MFSA, and indeed the team responsible for trustee supervision, is also responsible for the register of beneficial owners of trusts in Malta. So obviously, my team was involved in first of all, in the transposition of the legislation relating to beneficial ownership registers of trusts, and also to the development of the register itself, as well as being responsible for its maintenance. Thank you.
Thank you. Thank you, Petra. Last but not least, Stefan, over to you, please.
Thanks, Amar, and thank you, Sigma Risk. I'm Stefan. I'm currently president of MACO, which is the Malta Compliance Officers Association. Our members are mostly compliance officers and MLROs, but also others operating in the financial services industry. So we have people from banking, insurance, investment, CSPs, from all the sectors, really. And my role here today is perhaps to put questions and also to give inputs on what service providers and licensees are actually facing and experiencing in the process.
Thank you, Stefan. So the idea is that what we want to do now, we just want to run a couple of polling questions to give us some information about your problems or your challenges that you face from the industry perspective, right? So very brief couple of questions. The first one, I'm launching it now. It should be coming up on your screen. So the question is that regarding ultimate beneficial ownership. So what do you think about regulatory guidance on ultimate beneficial ownership in Malta? So is it easily accessible, clear and concise, or is it easily accessible but it's difficult to understand, or it is not easily accessible, difficult to find where it is and difficult to understand? So let's see what you think, and that will give a very good indication to FIAU and MFSA and MBR here as well, who are the key stakeholders to make things easy for all of the industry here as well. So I will give another 10 seconds. So we have received 70 to 80 responses so far out of 180 participants. So we got really good attendance now. So thank you very much to all once again for joining this webinar. Okay, so we got 100 responses. So just maybe I'll give another 5 to 7 seconds. Okay, so I will end the poll and I will share the result on the screen for everyone as well. So majority, nearly half of you, you think that guidance is easily accessible, but it's difficult to understand. Okay, so they know where to go and find the information. That is a good sign at least. And then maybe a little bit of work to do as to thoroughly understand it. How does it mean and how to implement it as well? And then the second highest answer was, of course, is the first one's easily accessible, clear and concise, which is very encouraging. And the very small proportion is that it's not easily accessible. So I think there is a little bit of work for MFSA and FIAU to do to make it a little bit more easy to understand and implement. So thank you very much for your answers. I will launch the second poll as well. It should be coming up on your screen now. The key challenges for UBO identification and verification. So what do you think are the key challenges in identifying and verifying UBO information? So you can, I believe you can actually select multiple answers as well. So either the information is not readily available through beneficial officer beneficial register, or the information is available in BO register, but different to what is actually provided to us by the clients, and the client is resistant to provide the information. And the last one is the complex ownership structure make it difficult to truly unwrap the beneficial ownership. So I will give it a few more seconds. So we've got around 90 responses so far out of 182. Okay, in the meantime, I will like to highlight that there is a Q&A option here. You can see at the bottom of your screen. If you have any questions, please feel free to type in the Q&A section, and the relevant person, either from FIAU or MBR or MFSA or myself or Becca or Stefan, we will try our best to answer your questions. Okay, so I will close the poll now, and then we will share the results with you. So the results are coming up on the screen. Is that the majority, actually around 75% of you think that the complex ownership structure makes it very difficult to truly unwrap the beneficial ownership. And then 41% they think that the client resistant as well, that they don't want to provide the information due to whatever reason. And but another one, 31% each, for information available in beneficial ownership register is different to what the client has provided, maybe the discrepancy, and also the information is not readily available. So you see that there is a clear trend that 3/4, around 75% of you think, 100 people exactly out of 133 who have answered, is that the complex ownership structures, these are the ones which are making it difficult to truly identify who the people are behind the company formations in Malta. Thank you very much. So now we will go back to our main topic. So first of all, why we totally understand and appreciate that this topic is a complex topic. It is not always, not everyone who is actually in this session will be on the same page in terms of, you know, their exposure, their understanding of the subject matter. So we will start with the very, very basic question. Okay, so the first question that I would say should be as to what is beneficial ownership? You know, what is the definition of, you know, ultimate beneficial ownership? Do we really need to identify beneficial owners? And if we do need to identify, do we need to verify that as well? So let's get started with the very basic question. So I will start with the FIAU, Carmela. If you would like to open the floor today, what is beneficial ownership? Do we need to identify beneficial owners? If we do, then do we need to verify them as well? So let's start with that.
Thank you for this question. Yes, basically, first question, what we mean for beneficial owner. We have the answer in Malta in the PML-FTR, which is the Prevention of Money Laundering and Funding of Terrorism regulations, which in Regulation 2.1 provides a definition. So there is a different approach depending on the client of the subject person, on the customer. So when the customer is a company, we have to apply a particular definition, which basically says that should be deemed as a beneficial owner whoever directly or indirectly owns 25+1 or more shares in the company, or 25% of more or voting rights. Apart from that, it is really important that subject persons focus on understanding who is controlling also the company. So we have, first of all, understanding the ownership of the company, and then understanding whether there is someone else that is still exercising some kind of control. We say control through other means with respect to that specific customer. Moreover, we have to add that whenever it is not possible to determine who is the beneficial owner, because in terms of ownership and control, as a measure of last resort, then we have to refer to the so-called SMO, which is the senior management official. So if it is not possible to determine who is the BO, for example, because we have a fragmented shareholding, so everyone will be, I don't know, we have hundreds of shareholders with a few percentage of shares, it is just then that we can refer to the senior management officials of that company. This with respect to company. However, the PML-FTR specifies that when the customer is a trust, there is a list of different subjects that would be considered as beneficial owners. So the law is very clear in that, just list the different subjects that we can consider as beneficial owners. So in the case of a trust, we have for sure the settlor, the protector where available, the trustees, and then also the beneficiaries. So we have the list of these different subjects that are deemed as beneficial owners. Moreover, when we see other arrangements which are not trust but are similar to trust, then we have to take the same approach we take from the trust. So we have to say, for example, I don't know, a foundation, for example, which measure would I take if it were a trust? So I say, in the case of the foundation, we have the founder, which is very similar to the settlor. So I would need to consider the beneficial owner, the founder. Then the administrator, which is very similar to the trustee. So this is the rule. But to be honest, the implementing procedures are very clear in that, because they provide, when it comes to foundation, especially, they provide here again a list of subjects that are deemed to be beneficial owners. So for subject person, in this way, it would be easier to just carry out identification and verification on this subject. Then you said why we need to identify the beneficial owner. This is a very good question. And with respect to that, we have to do a step back, let's say, and go to the FATF that provides a very important recommendation. It is recommendation 24 that, as we know, the FATF, the recommendations are addressed not to subject persons, but to the countries. And in recommendation 24, it is clearly established, there is this recommendation that says that countries should take measures to prevent the misuse of legal entities for money laundering and funding of terrorism. So it is saying that companies companies, unfortunately, can be used, and other legal entities can be misused for money laundering purposes. So it is here that we can see the importance of understanding who is behind the company, because the company per se is just a legal entity. So we have the company that is a legal entity, and then we have a natural person, and this would be the beneficial owner. So it is important understanding who will be profiting from this company, who will be benefiting of the asset and the activities that will be going on in the company, because this is the person that will be probably, in the case of, let's say, an illegitimate plan, will be benefiting from that plan. So we, in the way that when we can understand who is behind the company, is like we would delete, distract that screen that protect the natural person from the screen of the legal person. So this is a concept that it is really important. So basically, the beneficial ownership legislation is there to make sure that companies and other legal entities are not misused for illicit purposes, in primis money laundering, but also other crimes. Then you said identification and verification. This is a query, I have to say, that we receive very often, because now we know that the AML and CFT system is based on a very basic and important principle, which is the risk-based approach. So every subject person should apply, when it comes to AML and CFT obligations, an approach that is based on the specific risk that it is encountering when providing a services or carrying out a particular transaction. So what subject person should do is assessing the risk. Now, when the risk is low, so if while providing a particular service, it comes clear that the risk is low, we can somehow postpone the verification. So identification should obviously always be carried out at the beginning of the business relationship. When it comes to the verification, it can be postponed in low risk scenario, but of course, at some point, verification should take place. In fact, regulation 7.1b of the PMLFTR clearly says that one of the main CDD obligation is identify and verify the beneficial owner. Now, with respect to the identification is simple. Identify means just collecting the details. So I know that my client is Mr. X, that he lives there, he was born there on that date, etc. So just collecting details. When it comes to verification, is just making sure that that information that was provided is accurate, is true, and that most importantly, that Mr. A is actually Mr. A. So through an ID card, I can just make sure that that person is actually the person that says to be. So it's not a very complex procedure, but it is important that verification is carried out in accordance with the risk that was previously assessed. So in low risk scenario can be postponed. In high risk scenario, also when it comes to documentation, sometimes just one document might not be enough. So I might ask for some more documentation depending on the risk.
Thank you, Carmela. That is a very comprehensive answer. I think it should have made a lot of questions very clear now for our participants. So thank you very much. So now I'll come to Petra. Petra, from MFSA perspective, is there any guidance available from MFSA as well, especially coming to the corporate trust perspective as well? So the beneficial ownership. So what is the stance of MFSA in terms of UBOs, identification, verification, and different type of entity setup? So do you have any comment to add from MFSA perspective as well?
Yes, what I can add here is that, in fact, the main legislation, of course, relating to identification and verification of beneficial ownership, the first source, so to speak, is always the prevention of money laundering regulations and the FIAU implementing procedures. So that is always the first main source. However, given that we appreciate the key and what an important role this has in establishing a business relationship with any client of a trustee or a client of a company service provider, our rules even actually make direct reference to the fact that trustees and CSPs need to have sufficient systems and controls in place to ensure that they can fully identify and verify the beneficial ownership information of their clients, whether it's companies in the case of company service providers, or whether it's trusts for trustees. And in fact, our rule books make direct reference to the AML legislation, because we want to give that primary importance in terms of the obligations of trustees and CSPs. So definitely it is very important for us. And we also, as part of our supervision, make sure that they have the correct systems and procedures in place to be able to comply with these requirements. So definitely these requirements, possibly because we recognize the gatekeeper role which a trustee and a CSP plays, we definitely give this paramount importance even in our rule book by cross-referring specifically to the AML legislation and making it sort of a key requirement which trustees and CSPs are expected to comply with. Apart from that, as I said, we are also the owners of the Register of Beneficial Owners for trusts. So we have specific guidance as well in that respect, but perhaps we can go into that even further later throughout this webinar.
Thank you, Petra. So now I think very comprehensive answers from both FIAU and MFSA perspective. Now the question is that where can we actually find the information from the beneficial ownership perspective? I will come to Geraldine, who is the registrar of companies in Malta. Does Malta have a beneficial ownership register? Is it free to access? What information is available in the Maltese beneficial ownership register? Is it verified when someone gives you information? Is it verified, or is it just collected and stored in the database? So Geraldine, would you please talk us, just talk about the question that I've just asked in terms of the beneficial ownership register in Malta, is accessibility, the trust that we can put into it, whether the information is correct or not, and how frequently, for example, it is updated, is it free to access, etc. So over to you, Geraldine. So many questions, sorry.
Yes.
But we can do one by one.
No problem. We'll start bit by bit. So in relation to your question of the Register of Beneficial Owners, yes, indeed. We have a Register of Beneficial Owners for all legal persons as well as other organizations. And I want to explain this a little bit more. So we have the most popular Register of Beneficial Owners in relation to commercial partnerships, and those include companies. But we are also in charge of the Register of Beneficial Owners of foundations and registered associations. In addition to that, we are also in charge of the Register of Beneficial Owners of unregistered associations. And Amar, if you allow me to briefly explain this latter part, since a jurisdiction cannot impose any registrations on associations, as otherwise the freedom of association will be restricted, they are still obliged to file beneficial ownership information with the DMBR. These unregistered associations, for the purpose of our audience, are mainly voluntary organizations which are enrolled with the Commissioner for Voluntary Organizations in Malta, cooperatives, sports organizations, and band clubs, and the like. So these are all obliged to file information on their beneficial owners, and this information can be accessed through our portal. This obligation, needless to say, emerged from the 4th ML Directive, and when we have transposed the 4th ML Directive, access was given to competent authorities and subject persons and individuals with legitimate interest. With the transposition of the 5th ML Directive, it has become obligatory to have the register open to public inspection. And in fact, our registry on beneficial owners is open to the general public to inspect. It is important to mention that although the FATF requirement in Regulation 24 does not mention and does not make it obligatory to have a central register in place, however, the spirit of the FATF recommendations, if you go thoroughly through them, still encourages this approach of having a register of beneficial owners in order to ensure that there is accurate and up-to-date information. The FATF refers to this approach as the multi-pronged approach, that is, having beneficial ownership information at company level, registry level, and existing source level, such as subject persons and other competent authorities. In relation to access, one final point I need to mention on the register of beneficial owners is that there is great cooperation at EU level, and that there is going to be the launch of the bodies, the beneficial ownership register and interconnection registers, whereby all EU member states are going to be connected to this platform, and beneficial ownership information is going to be shared across all the EU with regards to companies, associations, foundations, and also trusts, which was under the MFSA remit. And as Malta, we are already connected to this EU platform. We are still, of course, awaiting tests from the EU Commission that they have to undergo tests, etc., in order to ensure that the system is working properly, etc. In relation to access, the registers are completely free to all competent authorities, and subject persons and the general public have to pay a minimal fee of €5. A register can be accessible either through you go on the name of the company and you'll find the beneficial owners of that particular company, or else even with the reverse search, that is, you enter the name and surname and identification document number, and you will find all the involvements of that particular beneficial owner. It is also important to mention that as MBR, we have recently developed also APIs. APIs are, for those that are not familiar, like myself in IT, are when you offer your raw database via web services. That is, competent authorities, most of the Maltese competent authorities have access through our APIs, that is, access to our raw data, and they can search the beneficial ownership information free of charge, etc. And we are also extending this service of APIs even to subject persons. And of course, subject persons will be asked to pay a fee in relation to this API service. The information which cannot be divulged are information relating to minors. That is, when you have minors being involved, SBO will have that information but will not be disclosed to third parties, and in exceptional circumstances, when there are justified cases whereby the access to such information would expose the particular beneficial owner to risk of fraud, kidnapping, blackmail, extortion, harassment, violence, etc. And then these are catered for in the directive. Needless to say, the minors and the cases that I've mentioned still are available to competent authorities, credit and financial institutions, and subject persons alike. So these are not just available to the general public. I believe the final question was in relation to verification from MBR side, right? Indeed. So, as I've mentioned, we are a supervisory authority, and therefore we need to ensure, and we have an obligation by the AML directive, we have an obligation to ensure that the information given by the MBR is indeed accurate and up to date. And we look at the verification process twofold. One in relation to factual accuracy, that is, whether the person indicated indeed exists or holds shares in the company. Therefore, we ensure that the person being disclosed is in possession of a passport, etc., whereby we can identify that that person indeed exists, and that he prima facie, he holds shares in that company. However, and most importantly, I believe, is also the interpretive accuracy, that is, whether a person should be considered a beneficial owner due to the familiar relations or other means of exercising control over a company. And this is quite tricky. And sometimes this is missed by subject persons and companies as a whole. This, when to give an example, is, for example, having the right to appoint all directors, the nominee shareholding, etc. These needs to all be disclosed at registry level. We do verifications both at registry level and also at compliance unit. In brief, the registry unit is in charge to check that the details match with the identification document we require. The certification needs to be made on the identification document. We ask for a copy of the identification document, which is certified by a audited professional at the registry unit. They actually check that the information is correct and the certification is valid. The document need to also be government issued document. Also, at the registry unit, they cross-refer to other companies registered in Malta with similar companies. Therefore, you have a shareholder in a company, and then that shareholder, we checked at the registry unit, they will check that shareholder, if he holds shares in other companies, that the same disclosures were made. At the compliance unit, then they screen all beneficial owners and put them in assessment, so to speak, as a risk. They will have various red flags whereby these beneficial owners can be put. They will also check the structure of a company, and these are all flagged in accordance with the risk. We have also, so this process is done for all companies that are incorporated in Malta, as well as on an ongoing basis. Therefore, these checks are done with every beneficial ownership information form we receive. However, we have also ongoing verifications. We need to ensure that not only the initial disclosures are correct, that the company is keeping up to date with changes to the structure. And therefore, there's an obligation in the law that changes in beneficial owners are to be reported within 14 days from change. We also carry out on-site inspections, and on-site inspections are carried out on the companies per se. So these are totally different from what the FIAU and the MFSA do. Companies are also obliged to report annually on beneficial owners and to verify whether the information submitted is still correct, or if not, it's still not correct, they need to provide the relevant information. Also, as an additional measure, the law provides that subject persons and competent authorities are obliged to report discrepancies with the MBR. Discrepancies in the sense that if, for example, FIAU or MFSA carried out an on-site inspection, and when they verified the information they found on beneficial owners with that on our portal, they found that there is a discrepancy. This is reported to us, and then the MBR will carry out an on-site inspection. The same applies for subject persons. We have also went beyond the EU directive or the FATF recommendations, and we have opened such reporting facilities to the general public. Therefore, anyone accessing the beneficial ownership information on our portal can provide and is being asked to provide feedback on whether the information was correct or not. And if anyone from the general public clicks that the information is not correct, we treat it in the normal manner as if it was a report coming from a competent authority or a subject person. I'm sure that I left some items out, but we'll discuss at a later stage.
Thank you, Geraldine. Really appreciate all of the answers. Very concise, very clear. So I think one question that I have is more from the industry perspective. So we have the facilities available from the MBR perspective. The beneficial ownership is available, accessible. Information is verified as well. Again, MFSA, FIAU, from your perspective, you do perform on-site inspections, validate if everything is being correctly undertaken, etc. let's listen to the industry. Okay, how does the industry feel? Okay, we have Stefan here from Malta Association of Compliance Officers, very closely working with the industry across Malta, and Silvio here as well from Bank of Valletta as well. So please, one of you, just if you want to share something from your perspective, what do you think are the challenges or the key issues when it comes to identification of beneficial ownership, and then what are the key issues that you face, and so that we can shed some light for the benefit of the audience as well.
First of all, I need to apologize to everyone because I was a little bit late due to technicalities. I'm sorry for that. And Geraldine mentioned something. First of all, customers are still in a situation where they cannot distinguish or make the clear distinguish between the beneficial owner in the context of a legal person as that from the concepts of the legal and ownership and control. We still find that situation, which is basically, it's a big issue, right? Even when it comes to CSPs, I mean, and also this stems from the fact that there is the tools are there, the tools are available, but will still lack the culture and awareness, unfortunately, right? Even among CSPs, the importance. The most important that they update immediately. It's not something that you can procrastinate. It's not something that you can prolong. The update needs to be done immediately. Yes, MBR is there. It's efficient. We have all the data, but ultimately MBR depends on the efficiency of the customer, of the CSP per se, that he's going to update ongoing and in an efficient manner. Sorry. If it's not there, if he's going to procrastinate or is going to delay, we're still going to have the same situation, right? The data is going to present a challenge for the industry, right? Because it's a problem across the board, even in the subject as a subject person, the customer will prolong. He won't inform. I strongly believe that we need to inform more. For example, on a yearly basis, we need to issue documentation to customers, CSPs, highlighting the importance of the regular updates, right? Yes, sometimes this is even the situation with financial institutions. They are informed, right? They are informed in the opening of account that update the onus of the customer is to regularly update, but it's more than that. We need to inform them regularly, not just on the onboarding, but we need to continue creating culture and creating awareness, the importance, right? It is crucial to have the full picture, right? It's not part. Okay. Lastly, they go to MBR. The CSPs that they inform MBR at a very late stage, which ultimately is going to reflect on across all the chain.
Thank you.
I don't know what the others think, but it's a big challenge.
Thank you. Absolutely. The awareness, having everyone knowing the fact that where they can find information, what is their obligation. This is something, I think, the culture change, that is a very valid point that you've raised. Having the tool is good, but
Yes.
Making sure that people are aware of the tools and they know that they do need to use the tools as well, to make sure that they are in compliance with all the regulatory requirements as well. So I think one very important factor, I believe, Becca, you and I discussed recently as well, is having to know really who are the people behind a firm. For example, the US 50% rule, that is, from the sanction perspective, just for, we have an EU version of that as well. So sometimes we may think that, okay, we have identified one beneficial owner, or maybe there is not one beneficial owner, but there could be one person who might be retaining a majority stake in one particular entity through multiple entities. So this way, so having that knowledge and understanding of who are the true beneficial owners from the sanction perspective, that is very important as well. Becca, do you want to add any point on that as well?
Yeah, just to say, I've been fortunate enough to work with commercial banking units and focusing on this area around the world, and that, all the issues that Silvio mentioned are prevalent in many jurisdictions, not just Malta. So yeah, obviously complex structures, really understanding, and it's a bit like Russian dolls, isn't it? Unwrapping the ownership structures and getting to the human beings and looking across ownership structures to aggregate ownership under different limbs of a complex structure. I mean, give you credit, some of the structure charts I've seen of complex entities, it's page after page after page of legal entities and subsidiaries and parents and so forth. And really understanding that sort of aggregated ownership control is really important, because if you've got client A as a corporate entity, if you don't really follow that ownership chain through, as you've mentioned, Amar, you could be caught by not just not doing properly AML legal requirements, but sanctions issues. You mentioned the 50% rule. So again, OFAC is slightly different. OFAC has an aggregated approach as well. So if you have, without getting into the detail too much of it, you have two individuals who are each individually on an OFAC sanctions list, and they both have ownership stake in a company, you have to aggregate their ownership. And if it goes over that 50% threshold, then the entity itself is deemed to be sanctioned, even if the entity is not officially on the OFAC sanctions list. So unless you know that, and unless you're able to properly aggregate and calculate that, you're in trouble. And the same thing as you say, the EU is slightly different because they don't have that aggregation concept, but you still need to follow the ownership structure through. And I think as well, one of the big challenges for me is identifying and understanding where there is a nominee or where there is someone behind a named owner. So that may not always be readily apparent, and training frontline staff like relationship managers to actually identify, oh look, we've got a CSP in the structure. What is the role of that CSP? Is it a good CSP? Is it a reputable CSP, or is it a non-reputable one? And if it is a CSP, who is behind that CSP? One of the questions has come in on the chat from who was it from? Forgive me. A lady specifically, Kimberly, talking about the Cayman situation where a nominee in Switzerland is trying to hide behind Swiss law, and that puts you in really difficult positions. If there's local restrictions in another jurisdiction, again, you've got real problems. And I guess the last thing I would say is another real challenge is understanding things like other forms of ownership and control. For example, if you have a relative or a family trust in a structure where you might have 4 individuals named, 3 of which are children, one is the wife, risk of being sexist, one's the wife of a key individual, maybe a politically exposed person. You need to look at that ownership and say, who's the real controller in that family trust? And that is really technical. And for RMs in the first line of a bank, say, there's a lot of work involved in actually being able to identify and ask those questions. Some of you remember that amazing paper from years ago from the World Bank called The Puppet Masters. And that was one of the first papers that I think really started to ask these questions. How do we actually understand who's really pulling the strings of the puppet behind these corporate entities? And it's such a challenge for all of us in this space. But I think when you bring in complexity, when you bring in nominees, looking behind nominees, and you bring in things like indirect forms of ownership, I think that's where you get the big challenges in industry. Sorry, Stefan, do you want to come in as well, I guess? I'm sure you've got lots to say on this.
Sure. However, I would like to take a step backwards and understand a little bit and perhaps mention the more macro concerns which we have. We mentioned earlier on the definitions we have at law. Yes, we do have definitions at law. We do have definitions at law and also at soft law level. So if you compare and contrast what the EU directive says, it's not exactly in sync with what the FATF recommendation says. We do have the 25%, which appears in the EU directive, but it is used as an example, just as an example, in FATF. We do have, when it comes to sanctions, the other number of the 50%. Also included in EU documentation, 50%. So we do have an issue, at least most people have an issue, have a concern when it comes to definition. Where are we with definitions? Then again, the definitions are meant to help us, not bog us down. So as much as possible, we need to understand that the definition is there to guide you. It is not there to cage you. So you ultimately need to understand who you're dealing with, what structure you have in front of you, and ultimately who is in control. It's the element of control which I give much more weight than the element of shareholding. Shareholding is there, it's true, but I would emphasize and highlight the word control rather than the word shareholding. Also because we do all know that criminals, if criminals are on board, read the law as well. And they know how to go around the law as well. So if they have a percentage, if they have a threshold, they can easily try to go around the threshold. And just because you have a shareholding, it doesn't mean that you're stopping there and you're done and you're fine. There could be other flags, red flags, which are more of a concern. So that's one thing. One issue is definitely definitions. Then again, I would go perhaps even more backwards. The law itself. Bear in mind that we are 27 EU member states. This is a directive. Not everyone has applied, transposed identically the same. Also because it is a directive. Going forward, the provisions relating to the register are still going to be contained in a directive, the 6th directive, not in the new regulation. So once again, there is going to be a continued lack of harmonization between the 27 member states. So that is a realization we need to bear in mind. And I'm mentioning this because shortly I'm going to mention why this is important. Now, so we have 27 member states which should speak the same language, should. Okay? Then we compare with other jurisdictions. The US, for example, have in 2021, so last year, a new piece of legislation which more or less, let's give it a more or less, is in sync with this idea of registers. Once again, we're going to have a problem, or they are going to have a problem in the US. Why? Because the actual transposition of the law at the federal level is going to be depending on the different states within the US. So once again, even they are going to have a problem with harmonization. And obviously, one state will take advantage over the other. So that is the reality. I'm saying this because ultimately we don't live in just a tiny island and all our companies, all our, I don't know how many, I think it's something above 100,000 companies, give or take. Those companies, most of them do not involve just locals. Most of them do not involve just locals. They involve people from Timbuktu as well. So the problem with registers, and here I have a big problem with registers, in theory, is that the registers are as good as the weakest country. You need a link between all countries ultimately. Why? Because you have shareholders coming from A, directors coming from B, then C, then they change, then countries here, countries there. So you need to, as much as possible, have access and links to countries to understand the company you are dealing with. So the register system is as good as the weakest country or the country which plays foul. Let's put it this way. So we have the offshore territories, offshore jurisdictions, and even that is a discourse we have within the EU. Within the EU, we have mainland EU, but then we have the overseas territories, which sometimes are, you know how they are. It's, I wouldn't say Malta and Gozo because Malta and Gozo are the same, so we can't really use that example. But for example, let me take a very simple example. You have mainland, or sort of mainland plus water, Netherlands, but then you have Curacao. Okay, and I'm looking at Curacao because if you actually look at the register in Curacao, and the register there is not a very open one, I must say, or it gives basic data, very basic data. The register in Curacao is there is almost a company for every citizen or every resident or every national in Curacao. So it's a one-to-one relationship. So in a tiny island, possibly a bit smaller, a bit bigger than Malta, you have a one-to-one relationship. As many companies as there are residents or citizens or whoever, as the population count. And Here we're talking about a country which ideally should be speaking the same language, should be endorsing the EU directive principle. I'm saying this because the register is a good idea ultimately, but there are political arguments which weaken this idea. It's a good idea if everyone is on board. It's not a good idea if some people are semi on board, but then they're doing their other business in Curaçao. Okay, so that gives us an unlevel playing field. And I'm saying this because the more a register is open, free, accessible, the more likely you are unattractive to the investor. Now, bear in mind that not everyone is a criminal. There are investors who are, okay, bona fide, and they might be irked by the fact that your register is way too open, and that causes me issues. Also on a privacy level, if you like, as well, or not wanting to disclose whatever I have, that is also an argument. But we need to bear in mind that the more we are open, the more we become unattractive to the investor. So that is an important consideration. Okay, it's a bit non-legal, but it's an important consideration we need to take as a jurisdiction as well, because ultimately we're here as a jurisdiction as well. So that's an important argument. The argument of that we are not all on the same wavelength, yes, not even within the EU are we on the same wavelength, and that is obviously a big concern. And I would point a finger, in this case I'm going to point another finger at Luxembourg, for example. Luxembourg, which is, yes, the love child of France and Germany, are even going to court about the registers, and their register is still an issue. We have a couple of scandals as well with leaks and giving us a lot of information as well on the problems with the register in Luxembourg, including a recent article where we have some 300 minors being UBOs of companies in Luxembourg. There's nothing wrong in that, but it gives you the idea, the good sense, the good feel of what is going on with these registers or behind these registers. But that's at a macro level, but it's important for us to understand as a jurisdiction how attractive or unattractive we may become as well. Okay, and ultimately, yes, within the EU, we are friends, but we fight for the same bone as well. Okay, so that's an important argument. Also bearing in mind that now the UK is out and they have always been sort of the rogue in the room as well. Other issues which we have is information is not always available. If, for example, one of the shareholders is based in, we mentioned Curaçao, if he's based in BVI, if he's based in Switzerland, if he's based wherever, they won't disclose, they won't give you the information. How am I going to obtain the information? How am I to prove that I did try to get my homework right? It's not always possible. There are limitations, and then it's upon me whether I do have an appetite for this risk or not. So the availability is not always there. It's not always available. Even if you pay, it's not always available. Apart from the fact that there's an issue of accuracy. How accurate is the information? How up-to-date is the information? How correct is the information? It could be information which keeps changing all the time. Directors keep changing every other week. Shareholders, the same. Then again, this is why it's so important to us, especially us, including subject persons, to understand what is going on with the customer. Who is the customer? Who is in control? Okay, because directors change and shareholders might change, and that might be also intentionally done.
Stefan, can I ask a question on that? I think It's a really interesting point you make. And forgive me, I don't know the answer to this, but I believe certainly in UK local money laundering legislation, I think in the EU directive as well, certainly in the UK money laundering regulations, it makes the point explicitly that you shouldn't just purely rely on the beneficial ownership register when you're doing your due diligence. So because of all the points you've just made, and it doesn't matter how robust Geraldine and her systems are going to be, as you say, things change, people lie, you can't possibly validate 100% every single entry. So I guess it's all about taking a step back and asking, does this make sense? Do I really understand the ownership and control structure? Does it make sense? You know, as we were saying before the call, does the geography make sense? Why is this company in Malta? You know, why are the directors resident in this other jurisdiction? And I think there's a lot to be said for that common sense. And I couldn't agree more with your point about not getting obsessed with percentages or process. It's actually, you know, asking the basics. Do I really understand the ownership, and why? Does it make sense? You know, and if it doesn't make sense, asking questions. Can I, Amar, you've asked me to moderate some questions. Do you mind, Stefan, if I feed you and the rest of the panel some questions we've had from the audience?
Please, Becca.
Yeah, sure. So again, please, audience, lots of questions coming through for our panel. You see, we've got a great panel here. So if I can just looking back through the questions, I think our panel can all see those as well. So just look at the first one I've got here is from Stefan Galchi. So will the UBO features available in Malta be the same as the ones on the interconnected register? Sorry, I might have missed this aspect from Dr. Spiteri, Lucas's contribution. And the second part of his question is, when is the interconnected system expected to go live? Geraldine, would you like to cover that?
Yes, sure. In relation to Malta, we have all the IT infrastructure connected to the Boris. However, there are some issues at EU level in relation to how this is going live. One of the issues is that most of the EU countries do not have a fully populated register. So Malta is one of the first, not the only jurisdiction that have a fully populated beneficial ownership information register. And therefore, okay, they can connect. However, most of the EU countries do not have the information to merge with the EU platform. At this moment, Malta is connected. However, the EU Commission is doing some testing, technical testing in relation to IT matters on how this information is going to be shared. One of the issues is quite technical, is in relation to most jurisdiction, of course, charge a fee for the access of beneficial ownership information. And one of the problems is to find a common service provider in order for the fee to be paid. However, there is these technical issues that I don't believe that the Boris will be available anytime soon. Hopefully, yes, because as Malta, it would be an important source to verify information with other EU jurisdictions. However, I believe it will take some months in order to have a fully fledged Boris, so to speak.
Yeah, fantastic. Thank you, Geraldine. I think Petra, can I come to you as well on that? I think you have a perspective to share as well on this topic, on interconnectedness.
Yes, indeed. Because to answer the question, in fact, when somebody actually asked sort of, is it going to be available in the same way and in the same manner in terms of access levels? I think this is particularly important as well in relation to trusts. Because for the trust beneficial ownership register in Malta is not available to the public. We are in fact in line with what the 4th AML and 5th AML directive permits, basically, that we have different levels of access when it comes to trusts. So whereas under the 4th AML directive, the information was only available to competent authorities and subject persons, with the 5th AML directive, the access was widened. It did not go as far as being fully public, also because of some matters like what Stefan mentioned, in fact, that there were constitutional cases, especially in France, challenging public beneficial ownership registers for trusts. So the EU fell short of going fully public when it comes to trusts. However, it did extend access to persons who can demonstrate a legitimate interest, which needs to be tied with a suspicion of money laundering or terrorist financing. And also an access level which many people seem to perhaps ignore. There's a lot of focus on the legitimate interest, but there's another level which I like to call the semi-public access to trusts, which relates where basically the directive and our law as transposed says that it can also be given to any person who requests access to the beneficial ownership information of a trust which holds shares or interests in a company or a corporate which is established outside of the EU. And basically the EU, what the EU was trying to do obviously was, it obviously anticipated situations where with the public beneficial ownership registers of companies, a lot of companies would move outside of the EU, but then have business relationships within the EU, perhaps even through trusts. So basically, it sort of extended the semi-public access to trusts where they hold shares in companies, EU trusts, so to speak, which holds shares in companies outside of the EU. And that is accessible to any person. So it is that is why I call it semi-public to a certain extent, because it is through a request in writing. So with trust, it's much more complex. When it comes to, in fact, the interconnection, this is something even which as a jurisdiction we have been in a lot of discussions with the EU about, because there have been a number of member states in the EU which have opted to make their trust registers public, even though it is not required. Why? Very often because trust is not a very common vehicle in their jurisdiction. So in reality, it doesn't really make a difference to them. So it's actually probably more practical just to make everything public, might as well. Whereas obviously, given that trust is a relatively popular vehicle in Malta, we stuck to what is permitted by the directive at the end of the day. So we are in fact in discussions to make sure that these same restrictions, these same level of access need to be adhered to when it comes to interconnection of registers. And the idea is that indeed, for those member states who have opted to be in line with the directive at the end of the day, the same levels of access will be respected. But this makes it a little bit more complicated, because in terms of even access to competent authorities and subject persons, there are issues relating to identification and verification that you are actually a person working with a competent authority. So it gets quite complex. So in fact, the interconnection is being, so to speak, launched in a staggered manner, in fact. So as Geraldine said, it's not the case that sort of it will be something which will happen overnight, but it's something which is happening in a staggered manner.
That's really helpful, thank you. I'm going to come to Silvio and Stefan with a specific question in a minute, but first, can I just bring Carmela in? Carmela, you've volunteered to pick up some feedback on a couple of questions that have come in around the 25% concept and trust. I mean, would you give us your perspective on that? That would be really helpful.
Thank you. Yes, actually, the reason the 25% is coming from the directive. So it was implemented in Malta just when the EU directive was transposed. So it wasn't something that came up from Malta, but it was just the transposition of what was in the directive. But just to highlight that something that Stefan said before, it is important not to just focusing on this percentage, but taking into consideration the control aspect also of the company. Because very often we just focus on this percentage, and one subject persons have carried out this job, they feel that it's ready, they know who is the beneficial owners, but the reality is that what they need to focus is not just this aspect, but really understanding who has the control of the company, who will be deriving the profits of the company. And this is a more difficult exercise, but in a
I've seen some things, Carmela, for example, if someone's the historic founder of the company, but they actually are below that threshold, if somebody's on the management structure, these are all, forgive me, Carmela, but yeah, I mean, that's where I wanted to actually bring in Silvio and Stefan, actually. So Silvio, from your perspective, for example, most banks I deal with have, for higher risk customer relationships, they'll go typically down to 10% ownership.
Exactly.
But even that, it's not a black and white line, is it? Because if someone's got 5.5,
no.
you still need to look at their real power. Do you want to give us some views on that, Silvio?
The most important thing, as was Carmela and even other members of the team mentioned, the most important thing that we understand the definition of control here, right? In fact, I mentioned this, there is a distinction between the context of the legal person right? The beneficial owner in the context of the legal person as distinguished from the concepts of legal and ownership. Therefore, everyone needs to understand the concept of control. Who has the control? Who, for example, if I can be the shareholder, but ultimately there is a person who is doing the shareholder's loan. It's not me, right?
Yeah.
Therefore, I can be the shareholder. Fine, on books I can appear as the shareholder, but ultimately the funds are not going to the shareholder, but are going to Mr. X, who is basically the controlling party. Therefore, everyone needs to understand the concept of control here. Every subject person and the CSPs, so on and so forth. I think that's the most important thing. Yes, you can apply, the benchmark is 25%, but then every institution, every subject person can apply different percentages as a qualifying percentage for the shareholders, BO, so on and so forth.
Yeah, it's a
Therefore,
risk-based approach. Yeah.
If you see that there is a higher risk, if you see that the risk can be greater, then you can reduce.
Yeah. Silvio,
however,
basically, because if you ever get a Mr. X in an ownership structure, in my view, it's always a red flag. So Amar, did you want to come in there?
Yeah, I just have one point here. I have seen actually many times. Sometimes it's very easy to identify the UBO from the document. I have seen many situations where one company is actually owned by one individual who is a Swiss citizen. Right? And the company is based in Switzerland, which is apparently a low-risk jurisdiction, and the UBO is a Swiss citizen as well. Again, not a very high risk, not a big red flag here, but I have seen many instances where a lot of the time the UBOs are just the front faces. There is someone really on the background. One particular instance that I have personally picked up, where there was a Switzerland-based entity which is owned 100% by a Swiss gentleman around, I think, 21 years old. And then within a matter of a year or so, the company incorporated and started to generate the revenue, I think like $80 million within a matter of 1 year. And again, one or two people involved in the company. And then we really had to dig into it. Okay, fine. The document is saying that the ultimate beneficial owner is a 21-year-old Swiss citizen, but we really need to unwrap exactly who is at the background. So I actually had to do some proper investigative EDD, and then we identified actually it was one of the minister from the government of Nigeria who was actually behind that entity, who had appointed someone, a Swiss citizen, to open a entity in Switzerland and move around a lot of money. So when you just pick up from a bank's perspective, you think that you've done your job. Okay, we know we've got the document, we've identified the low risk jurisdiction, low risk UBO, you've done your screening, world check, whatever you use, nothing has come up, all good, done and dusted. No, but you really need to try to understand the background. Does it really make sense for a 21-year-old to be a one-man show and running a business of $80 million?
It's just the point that Stefan made before, isn't it? It's not. Yeah. Why don't we just come back to you to kind of close off this bit, Stefan? But what's your take on that discussion and the points that Mars just made there?
Well, when it comes to, again, when I mentioned thresholds, I mean, I don't believe in thresholds. I mean, I've had companies where the UBO had 1%, 2%. So you really need to read through the structure and understand what is going on and why, why it is being structured as it is. We have many different stratagems, and I mean, service providers provide stratagems for tax purposes, for other purposes, to come up with some sort of circular ownership, fragmented ownership. These are all stratagems which are used specifically for that, to confuse. Ultimately, it's a layering process, so we are confusing. We are adding more wires to make life a bit more miserable for our MLROs, if you like, and the authorities as well. But yes, ultimately, we need to understand and we need to have a holistic picture. And yes, sometimes there are red flags which are blatant, they are obvious. Sometimes you just see a simple company and then you start digging and you start realizing that there's a lot more to it than meets the eye. One thing I wanted to add is I myself, now this is my experience also as a previous MLRO, I do not rely on just the UBO registers. I consult them, I look at them, but I don't rest on those. when conducting my due diligence. I mean, I look at them, I try to understand, I confront the other information I managed to find, but I don't rely just on those. Also because, strictly speaking, there isn't a guarantee on that information.
Exactly.
So, as we said, I mean, no one would really guarantee that information. You consult, you include it in the file, but you rest on all the sources of information you obtain. If you manage to obtain, because as we mentioned, sometimes it is extremely difficult to obtain the information. And yes, the potential client is not there to help. The potential client is there to say, oh, but we're hiding behind Switzerland, so don't ask too many questions, or we're hiding behind any other overseas territory. So keep it low key. So information is not always available. But as I said, I myself do not rest just on the UBO registers. They're there, you consult them, yes, but that's part of the dossier you compile. It's not just looking at that. That would, to me, that would be the very lazy approach. With all apologies to everyone, but to me, that is the very lazy approach. Just looking at a BO register and saying, oh, yes, I'm done. No, you're not done. You just started at best. Okay.
It's just an indication, Stefan. It's just an indication.
Yes, you
For
are
example,
building a dossier.
Exactly. Economic substance, for example, it's a very good, it gives you an indication. You mentioned the nexus. I think Pekka mentioned it at the beginning, the economic substance. Why he is opening a business here, he's opening an account locally. Does he really need it?
Yeah. What is the intended purpose of the relationship? You know, what, and you say the geography is often a big factor in that, isn't it?
Exactly.
What I would also add is that registers ideally should give you all the history since day one, because in the history you realize how many changes have happened since the beginning. So there you're looking at shelf companies, shell companies. So history needs to be available. And I would, in an ideal world, yes, put functionalities. If, for example, I can look at, I don't know, nationalities, look up nationalities, and the list of nationalities comes up if I want to look and to focus on a particular nationality in this particular register, and all the names come up. I mean, the functionality will make the difference between one register and another, and will make a register useful or hard to use. Okay.
In fact, I would like, if I may, to add something to Stefan's. In fact, our goal is to have these functionalities as MBR. We cannot till now do this because of a GDPR problem. And I'll explain. The directors, shareholders, and all officers of the companies provide us with identification document numbers and the residential address, which are for GDPR personal data. Some would argue that companies are excluded from GDPR purposes. However, the data on the officers, on the shareholders, etc., are still personal data, and one cannot search by person because of these personal data imposed. So what we have done now, and it's already passed Parliament, we proposed amendments to the Companies Act, and these have been published already, that officers can opt to provide us with a service address. Once the register is fully populated with the services addresses, and those who provide us with the residential address who would have the consent of these individuals, therefore won't have a problem, will be able to move forward and give these functionalities to at least, if not to the general public, to at least competent authorities and subject persons. In fact, as MBR, we are investing in a new online portal, which we already put a lot of thought in relation to these functionalities, which should be available also to at least competent authorities and subject persons.
Stefan, you wanted to come in with maybe a challenge or a query on the GDPR issue there?
With regards to GDPR, we have cases, at least we have a couple of cases from Luxembourg. So that's a work in progress. We also have GDPR also being raised as an issue from Netherlands as well. And these are recent cases, they're ongoing cases actually. So we have challenges vis-a-vis the registers coming from a number of jurisdictions. I believe we also mentioned France at one point as well. So yes, GDPR is, let me be blunt, is an excuse, or is being used as an excuse. I myself do not like GDPR being pulled in as the excuse. Why? First and foremost, GDPR is the general law on data protection. Here we're talking AML, we're talking a special law. So to my mind, the special law takes prevalence over the general law. And I don't like this thing of data protection always being pulled in as the caveat and the blanket for everything. I mean, there's GDPR and there's GDPR. And even in Malta, we tend to go well overboard with GDPR being the excuse to our life.
Yeah, forgive me, Stefan. Thank you. Brilliant. You've bailed me out of a massive hole there, because I've actually confused you with another Stefan on the call. So I don't know, Stefan, if you have a response to what the other Stefan has just said very articulately there, please feel free to post that in the chat. Apologies, gentlemen. So look, GDPR, I think, as you say, often gets used in my experience as a, I'm not suggesting that Geraldine was using it in this context, but I've often heard, especially compliance officers sort of take it as the easy option out of a complex, challenging area. So from that perspective, I agree. So yeah, I mean, Amana, shall I pass back to you? I don't know if you want to sort of take the baton in terms of how you want to sort of progress the remainder in time we've got together. But thank you for all the comments and questions from the audience, and thank you very much to the panel. Some really interesting thoughts, I think.
Thank you, Becca. We've got around 8 to 9 minutes. So I think one question that I have is specifically from the enforcement perspective. I would like to ask from either Petra or Carmela. So cost of not doing your work properly, not identifying your UBOs, and any case study, anything that you would like to bring it, if you might have done an on-site inspection and then you might have found out that the things haven't been done the way they should have been done, and what can go wrong, what can be the consequences, because it is an important topic. We've seen a lot about beneficial ownership in like Panama Papers and Paradise Papers, and a lot of kind of big scandals that have been erupted over the last few years. So it is, of course, a very important topic, and it is important to get it right. But what may be the cost of getting it wrong from MFSA or FIAU perspective if an entity in Malta does not comply or does not do the things they should be doing? So would you like to add just a comment or so from either of your side?
Yes, from my side, I agree, because sometimes it can be really complicated, really understanding who is the BO. We understand even that subject person are making very often an effort to understand, and there are really scenarios which cannot be explained, or they require really a big effort to be explained. However, I think that subject persons in this exercise should always be careful on different red flags that might encounter when providing a particular service, because the red flags will guide them in detecting any case of concealment of beneficial ownership. For example, very often we see cases of subject person that receive maybe instruction from someone that is not even in the shareholding. So this is already a red flag. Why am I receiving instruction from someone that does not appear in the company structure? This is a red flag, and there I need to think. If I have a doubt, I have to submit an STR, then we will take care of it, but we should start from there. Or sometimes maybe you see just funds transacting in a company, and they come from someone that shouldn't be legitimate to actually send these funds. Or I don't know, very case that we saw recently, it was even published in a fact sheet. We published it in the end of December. It was actually focused on misuse of companies in order to conceal beneficial ownership. This case was about a company structure. So there was initially a beneficial owner. So, after some time, this beneficial owner was not there anymore. So there was someone else. But in actual fact, this beneficial owner was still providing, giving instruction, and still involved as it was initially. So this is another clear red flag, that apparently there is a change in the beneficial ownership structure, but in real fact, this is not the truth. So just be careful on what is happening, who is providing instruction, how the funds are circulating within the company. I think these are small signs, but if they put them together, they can give really a good input for a subject person to report and for us to start working on these cases.
Thank you, Carmela. So we've only got 5 minutes. Petra, I'll come quickly to you if you want to add any point, and then we'll wrap it up.
Yes, just a couple of points which I can add to Carmela. I think something which came out from this discussion and which is very important is that we need to move beyond just percentages and the definitions and just ticking a box to satisfy a definition. I think one of the things which personally from my experience, at least in supervision, and I've done a lot of on-site inspections myself, so I've seen all sorts and all colors and shapes. So one of the things which is always very concerning to me is that there isn't a culture of questioning and digging deeper. So it's not just understanding who has a percentage of beneficial ownership. I think the first question you need to ask is, why is there this complex structure in the first place? You need to understand the purpose. And something which when within my interaction with company service providers or trustees, something when you dig deep and you probe further, when you ask them, okay, fair enough. So fair enough, you've determined who the beneficial owner is, but do you know why there's all this complex structure with 5 different companies owned by another 5 different structures with trusts, transactions going from one trust into the other company, all ending up in the same beneficial owner? When you ask the question why, I always get a blank face, and usually the bottom line would be because that's what the client wanted. But why? And I think why needs to be the biggest question that everybody needs to ask. And when it comes to trusts as well, there's another concept there, is in, again, when in the true concept of a trust is that the settler should divest himself of control from a trust. So if the settler is giving a lot of instructions, wants to be constantly involved, again, there's an issue there. The settler should be detached from the trust structure unless there are settlor reserved powers. Again, and that's something which depending on who the subject person is. If you're the trustee, first of all, you need to see whether the settler has the power to give you these instructions or not. If you're another subject person, if you're a bank, for example, or any other subject person for that matter, don't rely simply on the fact that you are dealing with the trustee. Yes, true. That's how it should be. It should be the trustee who has full control. But there may be things in the background which you need to ask about. Are there letters of wishes? Is the settler giving instructions on a continuous basis? Again, is the settler allowed to give instructions? It could be that he has some reserved powers. But I think these are all things which we need to ask. And I think the key here is not asking but how much, but why more than anything. So
I do agree with you, Petra, 100%, but obviously it all boils down to the knowledge and the awareness. And that's what we need to instill outside there. Knowledge, more knowledge and awareness. Yep. Because they're at that point in time, they will start digging deeper and asking more. When they know what to ask, when to ask, and eventually why they are asking. The importance of asking more and digging more. I do agree 100% with you.
Yeah.
Thank you, Silvio. Becca, any last comment? Sorry, we're running out of time. Anything from your end?
I mean, look, I'm almost saluting you there, Petra, with all the comments you just made. I could not agree more. It's about critical thinking, but to Silvio's point, you know, we do our training programs all around the world. We have a practical CDD program, and we say to people, you know, if it's a complex structure, it's okay to ask, why is it complex? And you should be asking that. If the customer won't tell you or can't give you a plausible explanation, then you need to look at the risk appetite you have and think, is this for us? And I think your biggest defense is the first line. It's the relationship managers. It's the people doing the onboarding. We need to upskill those people to ask the right questions, to understand why they need to ask those questions, and that it's okay to ask the questions. And the last point I would say, there's also a massive increase in expectations from regulators, including the MFSA, I'm sure, of the quality of how we record these investigations. So how have we got comfortable, if there is a complex ownership structure, that that's an acceptable risk? What rationale have we got from the customer that is a decent structure and for reasonable tax planning. And what evidence have we got as to how we got to that conclusion? So there's a lot, and I could go all day about this. So I'll shut up now, Ahmed. Yeah, thank you.
Thank you, Becca. I think the last one from my end. Sorry, we exactly say 7:30 on your end. So the last comment from my end, as I promised at the start of this, actually when we actually launched this webinar. So one thing I'd like to mention at the end is as a gesture of goodwill from our perspective. Thank you very much for everyone for attending this particular session, and we're looking forward to hold next session hopefully in May. So we will carry on with our quarterly webinars for the benefit of Maltese community as a token of appreciation for all of you for joining this particular session. So we are Sigma Risk. We are actually a partner of International Compliance Association, ICA, in Malta, and we have actually discounted all of the ICA qualifications for anyone from Malta who may want to benefit from the enhanced knowledge and learning that comes from the ICA qualification. So this is something I wanted to mention for the benefit of all the users today. So anyone who may want to explore any of the professional qualification or trainings from ICA, then this is something that, that's a gesture of goodwill and a token of appreciation that we have a discounted qualification available for everyone in Malta. So I think that is all from my end, and apologies, we are a minute late already. Thank you very much for attending the session today, and we are looking forward to see you all in our next session. Thank you very much.
Thank you.
Have a nice day.
Good evening. Thank you.
Thank you.
Bye-bye.
Thank you.
Ciao.